Okay, good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here at County Court at Law Number 2. You have been asked to come to court today for what is called an arraignment. And what the arraignment is just an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning the case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are normally referred to as your most serious type offenses, whereas your misdemeanor cases are referred to as your petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum 20 years and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a capital murder, which is the highest felony, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you, you have a felony case, so you don't have to worry about those type of punishments. However, misdemeanors are divided into 3 categories. We'll start at the top, work our way up down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, the Class C misdemeanor is cases that start in the JP court or the municipal court or city court. They come to this court when they are found guilty in the JP court or the city court, and then the person appealed the case. In essence, they want a new trial. And so the case comes up to this court, which is County Court at Law, and they get a whole new trial. Now, the range of punishment for a Class C misdemeanor is by fine only. That is, you cannot be given jail time. You only could be given a fine, and the fine cannot be above or cannot exceed $500. Now, just for an example, a Class C misdemeanor would be a traffic offense like speeding or not having your seatbelt on. Those are traffic offenses, Class C misdemeanor. Now, I mentioned to you that you cannot be given jail time for a Class C misdemeanor. It's by fine only. However, if you fail to pay the fine, or if the fine was converted to community service and you fail to perform the community service, then the court can issue what is called a capious pro fine. What that means is this: it's a warrant for the person's arrest for them to either pay the fine or sit the fine out in jail. And if they sit the fine out in jail, they will be credited at $100 per day that will go toward the fine and court costs. Now, the next highest misdemeanor is a Class B misdemeanor. Now, the range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days in the county jail, or you could be given a fine that does not exceed $2,000, or you could be given both such jail time and a fine. Now, the highest misdemeanor is a Class A misdemeanor. And with the Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days in the county jail, or you could be given a fine that does not exceed $4,000, or you could be given both such jail time and a fine. You may be eligible for probation. There are two types of probation. One type of probation is called unadjudicated probation, and the other type of probation is called adjudicated probation. The difference between the two is as follows. With unadjudicated probation, it does not result in a conviction on your record. And if you successfully complete the unadjudicated probation, we commonly refer to it as deferred probation, you will not have a conviction on your record, and the case will be dismissed, and you may qualify for what is called a non-disclosure. And what a non-disclosure is where your record is sealed to the general public. The operative word that I use is general public. Most of the public is general public. Now, the Code of Criminal Procedure allows certain governmental agencies to have access to it, but most of the public is the general public. So, for example, you're working at Exxon and you have a non-disclosure, Exxon can't go into you and see it. It's sealed. Okay. Now, but the police department, of course, they can have access to it. Now, the other type of probation is called adjudicated probation. We normally refer to it as regular probation. You do have a conviction on your record. However, there's something that is called judicial clemency. And what judicial clemency is it means that the judge can set your conviction aside and you will no longer have a conviction. In order to qualify, three things has to happen. One, you have to successfully complete probation. Two, there cannot be any more time left on the probation. And three, the probation office has to successfully discharge you off the probation. If those three things happen, the court can give you what is called judicial clemency. And if you get judicial clemency, you won't have a conviction on your record. Now, however, if you get another conviction later on, we call it a subsequent conviction. Another conviction later on. If you get a subsequent conviction, then the case that you received judicial clemency on can be brought back up. It can be resurrected, revived, and brought back up and used against you. Now, if you try to get a license with Child Protective Services, which is called CPS, they can deny giving you a license, or if you have a license, they can revoke or suspend that license. Now, everyone here should have a clipboard. I'm getting ready to go over that clipboard, which before you leave out here, everyone is going to have the clipboard filled out. Now, that first long page is after the short page, should be titled Judge's Explanation of Rights to Defendants Without Attorney. That document tells you about your right to have an attorney. As a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, you may request that an attorney be appointed by the court to represent you. And number three, you may represent yourself. Now, the first paragraph below number 3 states that if you want an attorney and you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date to give you time to hire your attorney. The next paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you, but you must first fill out a financial questionnaire. Now, the financial questionnaire is a 3-page document that is also on the clipboard. It should be right behind the judge's explanation. It's titled Affidavit of Indigence, or Jefferson County Affidavit of Indigence. On that document, you would have to fill out, for those of you, now, let me tell you this. If you are not requesting a court-appointed attorney, you don't have to worry about this form. This form is only for people who are requesting a court-appointed attorney. So if I go back to the first form, if you're going to hire an attorney, this is the only form you're going to sign. You don't have to worry about nothing else that you're ready to say. Okay? This is the only form that you will have to sign. If you want a court-appointed attorney, then you'd have to fill out this document that is titled Jefferson County or Affidavit of Indigence. You would have to fill out the entire first page. You can turn to it. You would fill out the first page, and then you'll go to the second page, and on the second page, you will fill out the top portion up here that says defendant's oath. Okay? And after you fill that out, then you'll fill out the portion at the bottom that says unsworn declaration. Well, it says unsworn declaration by defendant, and then you'll stop. That'll be it. All right. Now let's go back to the first form. Now, that third paragraph below number 3, this is for individuals who will be representing themselves. Okay. You have a right to have an attorney to represent you, or you have a right to give up the right to have an attorney and represent yourself. All right. So this third paragraph is talking about that. It says that, now, let me back up. If you represent yourself, you are your own attorney. Just like your attorney could talk to the district attorney's office about your case, you can too. We have 3 prosecutors in court. They work for the Jefferson County District Attorney's Office. If you represent yourself, you'll be able to talk to them to see if you can work out something on your case, because you're your own attorney. Now, this paragraph states that you may not speak to the prosecutors unless you first sign a waiver of your right to have an attorney. Okay. So once you sign the waiver saying that you know you have a right to have an attorney, however you're waiving or giving up your right to have an attorney, you would like to represent yourself. Once you sign that document, you'll have an opportunity to talk to one of the prosecutors to see if you can work out something in your case. Now, as I mentioned to you earlier, you cannot talk to him unless you first sign a waiver of your right. Now, the waiver is a document. This is only for people who will be representing themselves. This document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You would have to read this document and sign where it says defendant and dated today's date. All right. So let's go back to the first form. Now, for those individuals who will be representing themselves, this paragraph, the second to the last paragraph, which is in block form, states that be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of firearms, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, the last paragraph down here, this is for individuals who are wanting to represent themselves. They say if you want to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. So, for example, let's say you would like to represent yourself. And let's say you would like to see if you want the state to give you probation. That's what you want. And let's say you talk to the prosecutor and they say, well, we want to give you jail time. And you say, well, I don't want jail time. Judge, I changed my mind. I want a lawyer. Okay? you can do that. You can change your mind at any time and request that an attorney be appointed to represent you. All right. Now, at the bottom of this document, in bold letters, it states defendant's choice. Now, I'm on the first form. Defendant's choice. Mark initials next to only one choice. Everybody's going to sign, make a choice on this form. Everybody's going to make a choice. If your choice is to hire your own attorney, you will place your initials on the first line to the left at the bottom. You sign the form where it says defendant, dated today's date, and then that's it. This is the only thing you have to sign, you finish. If you have already hired an attorney to represent you, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right, if you already hired an attorney. Sign, dated, and stop. If you would like to apply for a court-appointed attorney, you will place your initials on the third line to the left. And then you will fill out the document that I mentioned earlier, the affidavit of issues, the first page of this document. And on the second page, you go to the top where it says defendant's oath, you fill that out. And then you go to the middle portion where it says unsworn declaration, you fill that out, and then you'll stop. Okay. If you've already been appointed a court-appointed attorney in your case, then you'll place your initials on the fourth line to the left at the bottom if you've already been appointed a court-appointed attorney. And then you'll place the attorney's name in the line to the right on the fourth line. If you would like to waive your right to an attorney, that is, give up your right to have an attorney, you would like to represent yourself, then you'll place your initials on the fifth line to the left, which is the last line, and then you'll sign on the line that says defendant, and you will date today's date. Okay, do we have any questions before I go any further? Anybody have any questions? Okay. Okay. Now, we're going to give you time to fill out that paperwork. Okay. I need to go over another right that you have. Now, you're here, you can enter a plea of not guilty, not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you have been charged with. Or you can enter a plea of what is called no contest, no to kindred, which means you will not be contesting or you will not be fighting the charges. Okay. Now, as a defendant in a criminal case, you have a right to have a trial by jury. When those young people are sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all of the evidence that's being presented by the state and by the defense. They will listen to the arguments by the state and the defense. And then they will go into the jury room in the back and deliberate. And they can either find you not guilty or guilty. You also have a right to waive your right to have a jury trial. That is, you can say, I don't want to have a jury trial. I want a trial, but I don't want to have a jury trial. Well, if that's the case, you have a right to have what is called a bench trial. The judge sits on the bench. So it's a trial by judge, where the judge will be the judge and the jury in the case. The judge will listen to all of the evidence. The judge will listen to the arguments that's presented by the state and by the defense. The judge will apply the facts to the law, and then the judge will decide to find you either not guilty or guilty. Now, you also have a right to enter a plea of guilty or no contest, and that's when you want to enter into what is called a plea bargain. There are 2 types of plea bargain. One type is called an agreed plea bargain. Agreed plea bargain means that you and the state have reached an agreement. For example, You wanted probation. The state offered you probation. You say, well, I'll take that. Then that's an agreed plea bargain. You agree. It comes before the judge. The judge can do one of two things. The judge can accept that plea bargain agreement or reject that plea bargain agreement. Now, if the judge rejects your plea bargain agreement, the judge say, okay, well, I'm not going to follow that plea bargain agreement. You have a right to take back or withdraw your plea. For example, you wanted probation, the judge said, well, I'm not going to follow that plea bargain agreement. Well, he said, judge, since you're not following the plea bargain agreement, I take my plea back. And that means I'm not entering a plea of guilty in no contest. Okay, so you go back to square one. Now, if the judge does follow the plea bargain agreement, and let's say within 30 days you decide, you know what, I want to appeal my case because I think I've been wrongfully convicted or the court committed an error by convicting me. If that's the case, then you have to get permission from the judge that followed the plea bargain agreement. Now, if the judge gives you that permission, your case will leave this court. It will go to the Ninth Court of Appeals, which is right upstairs, right above us on the third floor. There are 4 judges up there, justices. They will review your case. They can do one of two things. They can grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty and the case is over. Or they can send the case back down to this court with orders. Or if they reject or deny your appeal, no problem, because you can appeal it to a higher court than them. You can appeal your case to the highest criminal court in the state of Texas, which is called the Texas Court of Criminal Appeals, and they're located in Austin, Texas. Now, you have to file what we call a pro se petition for discretionary review. I will explain that to you. Pro se means self. I'm representing myself. Now, I don't have a lawyer, I'm representing myself, and I'm petitioning Texas Court of Appeals to review my case. Why? Because I want to see if my appeal should have been granted, or I want to see if I was wrongfully convicted in this court, or whether or not the court committed an error. They can do one of two things. They can either grant or deny your petition. If they grant your petition, then at that point, they can simply find you not guilty. Case over. Or they can send the case back to the Ninth Court of Appeals with orders, or they can send it back down here with orders. Now, if they deny your petition, then at that point, your conviction will stand. Okay. Now, the other right that you have is you have a right to have like an uncontested, not like I said uncontested, but unagreed plea bargain. Let's say you're in the state of talk, you want a probation, they want to give you jail time, you still want to plead, you can't come to an agreement, but you want the judge to decide what your punishment will be. Okay? We call that an unagreed plea bargain. And the judge will simply give you punishment anywhere within the punishment range. Judge can give you probation, deferred or regular probation, jail time, a fine, or jail time and a fine. Okay. Now, the other thing that you have a right to have witnesses to come to court. And what witnesses do, they sit in that chair right there that has the microphone. We call that the witness stand. They can testify for you or against you. If you're representing yourself, you can ask some questions. If you have a lawyer, your lawyer can ask some questions. We call that either direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses to come to court. If you waive or give up your right to have witnesses to come to court, that does not mean that the state will not be calling witnesses. They will be calling witnesses in your case. Now, you also have what we call a Fifth Amendment right against self-incrimination. What that simply means is this. The United States Constitution gives us the right not to incriminate ourselves, not to testify against ourselves. What that means is the state, the government, the district attorney's office cannot force you to take the witness stand to testify against yourself. If you think about it, it makes sense. And the reason why it makes sense is because the state of Texas, the district attorney's office has the burden of proof. That means they have the burden, they have to prove you guilty beyond a reasonable doubt. You don't have to prove yourself guilty beyond a reasonable doubt. That's not the law. So a lot of times we watch television and we see stories like Law and Order on television, and we see the television lawyer go up to the witness stand to ask the witness a question, and the witness say, "I take the fifth." What they're saying is, I'm not saying that. I'm exercising my Fifth Amendment right against self-incrimination. I have a right not to say nothing. I'm not saying that. We all have that right. Okay, now you can waive or give up your Fifth Amendment right against self-incrimination. If you waive or give up your Fifth Amendment right against self-incrimination, that simply means that you will be taking a witness stand. Okay? Now, the other right that you have is called discovery. And what that simply means is this. You have a right to see the evidence that the state or the government will be using against you. You have a right to have access to your statements, witness statements, police reports, lab reports, photos, video recordings, audio recordings. You have a right to see documents, instruments, whatever they have, whatever they've been using against you, you have a right to have access to that before trial. Now, you can waive or give up your right, and if you waive or give up your right, then you would not have access to it. Now, everyone that's here today, charges have been filed against you, you've been arrested, you've been placed in jail, you're out of jail, either on a cash bond, which means that you paid the full amount of the bond to get out of jail, or you're out of jail on a surety bond, which means that you paid a surety, a percentage of the bond to get out of jail, or you're out of jail on what is called a PR bond, or a personal recognizance bond, which means that you did not have to pay any money to get out of jail. You were just released under your own personal recognizance. I've said that to say this. Every day that you spent in jail can be used as credit towards your punishment. So, for example, now, the operative word that I used was every day can be used. So let's say you were arrested and booked in jail at 11:59 p.m. last night. You booked out of jail at 12:01 a.m. this morning, 2 minutes later. That's 2 different days. You was in jail 2 minutes, but it's 2 different days. And so you get credit for 2 days. Okay? Now, let's say you spent 5 days in jail, talk to the prosecutor, they're offering you to serve 5 days in jail. You would not have to serve any more time in jail. Why? Because you'll be given credit for the time that you've already served. Now, if the state is offering 7 days in jail, you serve 5, that means you only have to serve 2. Because we'll subtract 5 from the 7, that leaves 2. Now, every day that you spent in jail can also be used as credit toward your fine and court costs. You are credited $100 for every day that you spent in jail. So in our scenario, you spent 5 days in jail, that's $500 credit that you can use toward your fine and court costs. So if the state is offering you fine and court costs of $500, you don't have to pay anything. Why? Because your time in jail has already paid it off. Therefore, the fine and court costs will be what we call tax and retire. Now, if the state is offering fine and court costs of $700, that simply means that you'd have to pay $200 because you already have $500. You take the 5 from the $700, that leaves 2. You'll be required to pay that on the day that you take care of your case. Now, if you are unable to pay it, no problem, because we could put you on what is called a payment plan. You can pay off the fine and court costs in small monthly installments until it's paid off. But let's say for some reason you do not have the income to pay it off. No problem. Why? Because we can convert the fine and court costs to community service. And for every 1 hour of community service that you perform in a nonprofit organization in Jefferson County, you will be credited $12.50 per hour. So if you work 8 hours one day, that's $100. So you work 2 8 hour days in a nonprofit organization, that's $200. So your fine and court costs is taken care of. All right. Now, the district attorney's office has a program for first-time offenders. Let's say you haven't had charges filed on you, the first time having charges filed on you. Well, they have a program where they will dismiss your case, and you can get it wiped, and it will be wiped off of your record. Okay? The program is called pretrial diversion. It's for first-time offenders. 3 things has to happen in order to qualify. Has to be your first time having cases filed against you. 2, it cannot be an offense for unlawful carrying a weapon or resisting arrest. And 3, you have to have an attorney to get you into the program. The attorney could be a court-appointed attorney. It doesn't have to be a hired attorney. All right. And if you get into the program, they'll dismiss the case. You successfully complete the program, you can get it expunged, which means erased, deleted, or wiped off from your record. All right. Now, if you're a veteran of any one of the branches of the United States military, the district attorney's office has another program that is called Veterans Court. It's for veterans only. The only thing you have to do to get into the Veterans Court is be a veteran of any one of the branches of the United States military. And once you get into the program and complete the program, they will dismiss the case. And then you may qualify for non-disclosure, where your record will be sealed to the general public. This court, County Court at Law number 2 of Jefferson County, Texas, has a program that God led me to start within the first 100 days of taking office. The program is called the CSI program, which stands for the Community Safety Initiative. With that program, we have partnerships with local agencies. One of the agencies that we have a partnership with is Spindletop. Spindletop, they are a local mental health agency in the Jefferson County or the Southeast Texas region. And what Spindletop does, Spindletop has expertise to deal with mental health issues. For example, you do not have to be incompetent or insane to participate in the program. You could just merely suffer from anxiety or depression or any other host of mental illnesses, and Spindletop has expertise to address your mental health issues. Now, what they would do today, obviously there's a form on your clipboard that you have to fill out. That's a little short form. But what they would do a private interview either in our jury room, at their facility, by telephone, or whichever is convenient for you. Then they have the expertise to do an assessment to determine what your mental health issue is, and they can do develop a treatment plan for either outpatient or inpatient to address your mental health issue. If you have issues with drugs or alcohol, well, Spindletop has a program that is called ATAR. ATAR is an acronym, ATAR, that stands for Addiction Treatment and Recovery. We also have a partnership with our local drug and alcohol council that has a program that is called OSAR, OSAR, which is an acronym that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. And with those programs, they would do a screening, an assessment, and develop a treatment plan for either outpatient or inpatient treatment. And if you are unemployed or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. It's an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you're trained in any one of those areas that you choose, they will help you to get a job in the area that you're trained in. If you have not graduated from high school, if you do not have a GED, Lamar University has a program It's a GED program. And where you can receive your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free. It does not cost you anything but time. And I like to say in this court, we don't just give time, we take out time. That simply means we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I say that when you come to county court at law number 2, we don't just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individual that comes before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes in to the community. And so if you're interested in any one of these programs, just let us know. And we have brochures and there are people that you can talk to get you started in the program to the point where you'll be living your best life. And so, again, if you're interested in the program, just let us know. And as I mentioned to you earlier, we have some folks who Spinotop that's going to come and they're going to tell you more about their program. We have Caitlin and Deputy Otis and Tanya there with Spinotop. They'll tell you more about the program that they have to offer.
Thank you, Jim.
Okay.
Good morning, everybody. I'm Deputy Butler with the Jefferson County Sheriff's Department. I work along with Spinotop, and our job, along with Spinotop, if you become client with Spinotop, we're here to transport you to any doctor's appointment that you may have, or to come pick you up, take you back home. If you need any help with doctors, we have the proper paperwork that we file, so you can see the doctors that you need to see in order to help you with your situation. Ms. Caitlin, he's a qualified mental health professional. She can explain to you more about the top program. We also have Ms. Musette. He's also a part of the qualified mental health professional. Ms. Caitlin.
So on your clipboard, there should be a little small paper at the front of it, or that was at the front of it. And that is our form. It is optional. You do not have to fill this paper out. It is not a court document. It is a Spinotop document. So if you want to leave it blank, you can just turn it in with your clipboard. You can always use blank paper. So how to fill it out is pretty self-explanatory. At the very bottom, it says admin use. Don't worry about that. That's for us. You should worry about everything above the bold line. So if you were to check, I would like assistance with, if you were to check mental health, which could be depression, anxiety, or PTSD, or substance use, which can be any type of drug or alcohol, then we can help you get into Spinotop services or any other facility service to help you find support in the resources that you need for that. Now, what Spinotop provides is doctor's appointments to get medication for your mental health if you're interested. You can talk to counselors, we have therapists that you can talk to. For substance use, we have support groups and we have support classes, we have rehab, and we also have connections to other facilities in the area. It does not have to be Spinotop. So if you want mental health help or you want substance use help, it can be Spinotop or it can be anywhere else. Again, this is optional. You do not have to fill it out. Everything that you put on there and that you tell me is protected with HIPAA. So I don't tell the judge what we talk about. I don't tell anybody else unless you give me permission. If you'd like to talk to me in person today about these services, then write on your paper, please talk to me today. You can write it in the other slot on the paper. And when the judge is done with you, I'll come and get you. I'll pull you to a back room and we can talk privately about whatever's going on, whatever you're comfortable sharing. We're turning papers in with your clipboard and we're just gonna find you when judge is done with you, okay? Do you have any questions? Thank you for your time.
Okay. Thank you. Now, at this time, we will have Mr. David Cookie, who takes his chair. and he's gonna tell you about the program that Texas Care has been on.
Good morning. Hi, my name is David. I'm a peer support specialist for Texas Care. And, we work alongside Spindle and, we offer, qualified mental health professionals that come to you or to the school. Our main focus is children. And, we work with children ages 3 to 17. And we also have a sheet on your clipboard. And if you need services, I'll be here throughout the day. Really appreciate the opportunity that the court gives to do this, because I was sitting in, seat at one point, not in this court, but in another court. And it's just kind of nice to use community resources to help. And if you have any questions, I'll be here, and there's some flyers over there, and we can do the best.
Okay, thank you, Mr. Cook. Now, ladies and gentlemen, we're gonna give you time to fill out the paperwork. If you need help with the paperwork, we have our court personnel who's here, including myself, will be happy to assist you with filling the paperwork out. Now, once the paperwork is filled out, we will pick the paperwork up from you, okay? And we're gonna call you up before the bench, one at a time. Now, we're gonna put you in one of 3 categories. One is you wanna hire an attorney, or 2, you wanna apply for a court-appointed attorney, or 3, you would like to waive the right to an attorney and represent yourself. Now, if you are hiring an attorney, your case will be reset today, meaning that you'll be given time to hire an attorney. If you are applying for a court-appointed attorney, if you qualify for a court-appointed attorney, you will be appointed an attorney before you leave here today. If you are waiving your right to an attorney and you want to represent yourself, then you will talk to the prosecutor and y'all come to an agreement. Your case will be disposed of before you leave today. Now, we're gonna give you time to fill out the paperwork. It's gonna take a little time. If you need to use the restroom, there are 2 restrooms right outside in the hall. They have the mid restroom right in front of County Court Law Number 3, which is next door. And on the opposite side of the hall, we have the women's restroom in front of the 172nd District Court. Now, you'll be allowed to use the restroom. And then you can come back into the courtroom. Please do not leave the courthouse. If you leave the courthouse and we call your case and you're not here, then your bond that you all will be forfeited. A warrant will be issued for your arrest. You'll be arrested, and guess what? We have to go through this all over again, okay? So we don't wanna do that. And so this is just gonna take us a couple of minutes to get all of this paperwork done. And again, if you need any assistance, make sure that you let us know. You can raise your hand, and we have our court personnel who will be happy to help you now. Before I finish, at the top of the document, you'll see a line. It says the state of Texas versus, and there's a line. Please print your name on that line. It should be at the top of where it says judge's explanation. Just please print your name at the top of that document. It says state of Texas versus. Should be at the top left-hand corner. Make sure you print, and the reason why you gotta print your name, because some people sign in there, we can't read it. Because people have different types of signatures. Okay, so just print your name so we'll know where the paperwork goes. Now, make sure that be mindful that we're still in court, and so you need to conduct yourself accordingly. All right, so at this time, the court will be, yes.
Can the person sign up for program today or they have?
Yes, no, it can be done today. That's why we're here.
Without the attorney?
Yeah, I mean, no, the one pretrial diversion, you have to have an attorney. I said it was 3 things. It has to be the first time you get in trouble. You have to have an attorney. You cannot be an offense for unlawfully carrying a weapon or resisting arrest. And so once they get their attorney, they can tell the attorney that, you might be interested in that program, and then the attorney can apply. Yes.
What do you like school from there?
I live in the woodland.
Okay.
So can I still participate in programs even though?
That's a fly, and it's the district attorney, they'll let you know.
Okay.
I don't, yeah, I just know about the program.
The brain would be something.
Yes,
If you decide to get a
If
court
they
appointed
finish with the bill and go out to
attorney,
here so we can get there.
he's here.
the court appointed attorney, we have a list that we have to go down, they call it a wheel. So, in all likelihood, we'll give you information on how to contact your court appointed attorney, the court appointed attorney has 24 hours to contact you. And, it could be taken care of, probably maybe not today, because I don't think, we don't have any court appointed attorneys here today, at the end of the courtroom. Okay? Yes,
So if they apply for a program where they don't need an attorney, what happens to the charge?
what you mean, what program?
One of the, like the mental health program.
Oh, well, that's up to the district attorney's office.
Oh.
Yeah, that's up to the DA, yeah, okay. Anybody else? That's it. Any other questions? Again, make sure be mindful, we're still in court, so conduct yourself accordingly. If you need help, just let us know. Just raise your hand and we'll have someone, we have people coming around anyway to help you out with the paperwork. Once they're gonna pick the paperwork up from you, they're gonna call you up to the front, one at a time. Okay? Court is in recess.
Make sure you complete your paperwork before you leave out. If not, you will come along. Your chance to get it.
Okay, that's a
Make
clear.
sure you put your, I'm not sure if he told you, make sure you put your name on the top of that first where it says get a text with yours.
Okay, all right, now, okay. So, see y'all then.
All right, do not, when you hand me
Jefferson County Court at Law number is back in session. The court is in session with your Rayma docket. And the first case that I have is cause number 25 CCCR 1903. Case is style of state of Texas versus Jorge Miguel Lozada Martinez. You could ask him if that's his full name, Jorge Miguel Lozada Martinez.
Yes, Judge.
Okay, and Mr. Martinez speaks Spanish. I think he probably speaks some English too. We have our interpreter, Ms. Jennifer Raji. Mr. Raji, would you please raise your right hand? Mr. Raji, do you swear to interpret Spanish to English and English to Spanish, so help you God?
Yes, Judge.
You may put your hand down. How you doing, Mr. Raji?
Good, Judge. Thank you.
Okay. Mr. Raji, ask Mr. Martinez to to raise his right hand. Okay. Mr. Martinez, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Judge.
Okay, you may put your hand down. Ask Mr. Martinez how he's doing. I think he speaks some English. How are you doing, Mr. Martinez? You doing good? Okay. Now, I have before me a document that is titled Judge's Explanation of the two defendants without attorney. Ask Ms. Martinez if he recognized this document.
Yes,
And is this your signature on the line that's titled defendant?
yes, this is good. Yes, Judge.
And are these your initials on the line that state you would like to hire your own attorney?
Yes, Judge.
Now, this document is in English. Prior to signing an initial in this document, did someone go over this document with you in Spanish?
Yes.
And did you understand everything that they went over?
Yes, Judge.
And is everything in this document true and correct to the best of your knowledge?
Yes, Judge.
Okay. This case will be reset to give him time to hire his own attorney. Here you go. He can stand in front of the court coordinator, telling me to have a blessed day. Oh, before he does that, I need to give him some bond conditions. Okay. Now, this document is titled Standard Bond Conditions in County Code Law number 2. Okay, if you could, I'm gonna read it to him. It says, following return of a criminal information.
You want me to read it word for word, because it's not gonna translate with the word.
Okay. Well, following return of a criminal information in County Code Law number 2, all bail bonds executed for release of any defendant hearing or ordered subject to the additional conditions. Okay. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. And does he understand?
Yes, Judge.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submits to a test and tests indicates the presence of drugs and alcohol in the defendant's body.
Or see if they can use it and say okay. They see if it was yes, Judge.
Okay, condition number 3 and 4 does not apply. I have on the next page, condition number 5 does apply. And it states the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Okay, tell him that if he violates any one of these bond conditions, his bond can be revoked. And if his bond is revoked, a warrant will be issued for his arrest. He'll be arrested and placed in Jefferson County Jail. Okay, tell him he could get his reset from our court coordinator. Once he get his reset, he's free to go. Have a blessed day. And you have a blessed day as well.
Thank you, Judge.
Put the other number on there. Okay, Alan Van Cis, how you pronounce it?
correct. You had it correct the first time.
Van Cis?
Yes, sir.
Okay, now, Mr. Van Cis. This is cause number 25 CCCR 1994. Case is style of state of Texas versus Alan Van Cis. Mr. Van Cis, is that your full name? Would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. You may put your hand down. How are you doing?
Good.
Okay, now, Mr. Van Cis, who do you have here with you?
Yeah.
Okay, thanks for coming down here with your son. Now, Mr. Van Cis, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled defendant? Are these your initials on the line that state you'd like to have your case reset to hire your own attorney?
Yes.
Now, before you sign and initial this document, did you read the document? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay, Mr. Van Cis, your case is going to be reset to give you an opportunity to hire your own attorney. You can have a seat in that chair, wait for your name to be called. Once your name is called, go to the window. And then once you leave the window, you're free to go. You have a blessed day.
Thank you.
Kenny Bean Jr. Mr. Bean, your full name is Kenny Bean Jr.? Okay, Mr. Bean, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Bean, you may put your hand down. How are you doing, Mr. Bean? I'm doing fine, thanks for asking. Now, Mr. Bean, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
Is this your signature on the line that's titled defendant?
Yes.
And are these your initials on the line that state you would like to apply for a court-appointed attorney? I also have another document that is titled Affidavit of Indigence. You recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes.
Mr. Bean, before you sign and initial these documents, did you read the documents?
Yes, sir.
Do you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Bean, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. And the attorney that will be appointed to represent you is actually Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you. You will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you're free to go. You have a blessed day. Next,
His plate ready.
okay, who is it?
Okay.
Oh, this is what we said.
Okay, hold on a minute. This is cause number 25 CCCR 0190. Case is style of state of Texas versus Alfredo Gaitan.
Yes, sir.
Mr. Gaitan, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, Mr. Gaitan, you may put your hand down. How are you doing, Mr. Gaitan? How are you doing?
I'm doing fine.
You doing fine? That's good. Now, Mr. Gaitan, you're represented in your case by your attorney, Attorney Christy Cawthon. Ms. Cawthon, how are you doing?
I'm doing well, Your Honor.
That's good. And the state is represented in this case by Attorney Shane Hilton. Mr. Hilton, how are you doing?
I'm good, Your Honor. Thank you.
You're welcome. Ms. Cawthon, do you waive a record in Mr. Gaitan's case?
I do, Your Honor.
Mr. Gaitan, I have before me on my computer a document that is titled Information.
Yes.
This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Alfredo Gaitan, on or about March 30th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest detention. Mr. Gaitan, do you understand what you've been charged with?
Yes, Your Honor.
And to this charge, Mr. Gaitan, how do you plead guilty? Not
No.
guilty or no contest?
Not going to-
No contest?
Yes, sir.
Now, you're pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Gaitan, I also have before me a document on my computer that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes.
On page 2 of this same document, there are a set of initials on a line next to a box that's checked no contingent, which means no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, Your Honor.
And on the next document, that's titled Trial for Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, Your Honor.
And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargaining case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, Your Honor.
I also have a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant? Now, Mr. Gaitan, before you sign and initial all of these documents that I just showed you, did your attorney go over these documents with you?
Yes, sir.
Did you understand everything that she went over? Is everything in these documents true and correct
Yes,
to the best of your knowledge?
yes.
And Mr. Gaitan, are you a citizen of the United States?
Yes, I am.
State of States Exhibit 1.
No objection.
No objections. State's exhibit number 1 will be admitted. Ms. Carlton, you've advised and counseled Mr. Gaetan. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Gaetan, your attorney, Ms. Carlton, has advised and counseled you. Are you satisfied with her representation?
Yes, Your Honor.
Has she provided full, effective, and competent legal representation?
Yes.
Mr. Gaetan, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers are freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
Yes, we do, Your
What
Honor.
is the agreement?
Your Honor, we'd ask the court for 97 days county jail with credit for time served of 97 days. And ask that the court costs in this matter be taxed and retired.
Okay, Mr. Gaetan, the state is offering that you serve 90 days in Jefferson County Jail, but you would not have to serve any more time in the Jefferson County Jail because you've already served 97 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Mr. Gaetan, do you understand the state's offer?
Yes, Your Honor.
Do you think that the state's offer in your case is fair and just?
Yes.
And do you accept the state's offer?
Yes.
Okay, Mr. Gaetan, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Gaetan, this will conclude your case. If you do not have anything else holding you in jail, you should be getting out of jail today. Now, Mr. Gaetan, please stand next to the bailiff, follow her directions. Once you're finished following her directions, you can follow the bailiff and you have a blessed day.
Yes, sir. Thank you so much.
Okay. Leo Barzar. That's the case. Is okay, this is cause number 24CCCR 2548. Case is style of state of Texas versus Leo Glenn Barzar. Is that Mr. Barzar, is that your full name?
Yes. No, Glenn.
Leo Glenn? Okay, Mr. Barzar, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, you may put your hand down. Now, Mr. Barzar, who do you have here with you?
Sister.
Your sister?
Sorry.
Okay, what's your name?
Mildred.
Mildred Barzar? Vickers, okay. How are you doing? And how are you doing, Mr. Barzar? That's good. Now, Mr. Barzar, I have before me a document that is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
Are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes.
I also have another document that is titled Affidavit of Indigence. Do you recognize this document?
Yes.
On page 2 of this same document, there are a set of initials on a line next to the boxes. Check defendant's signature. Is this your signature?
Yes.
Mr. Barzar, before you signed and initialed these documents, did you read the documents? And maybe did your sister help you by going over these documents with you?
Yeah.
Did you understand everything in these documents? Yeah. Okay, so basically it has your name, your address, phone numbers, it has your financial information on that. And this document is the document that I went over that explained to you, you had a right to have an attorney. And you chose that you said you wanted to apply for a court-appointed attorney, is that correct?
Yes, sir.
Okay, now, Mr. Barzar, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you is Attorney Christy Kaufman. She's the lady that's standing right here. And, let's see, you know what? You might have to give him some bond conditions. If you need time to talk to him, you can. I see here, he has a Houston address? Is that correct? Okay, so we'll give you time to do that, then we'll call y'all back up.
Yes, Your Honor.
Okay. Oh, y'all probably can go outside. So, okay. Here you go. Who?
Oh, sorry.
I'm gonna do something, yeah.
Okay.
It's gonna be, it's gonna be this one. You can fill this out for me, just his name and false number. Here you go. I did. Latasha Green? Who's that? Okay. Shane. Is Haley still back here? I think this is,
For, Brian.
okay, why don't you come on? I think this is the one they wanted,
Put your person at table, please.
I think they wanted this case reset, if I'm not mistaken. Okay, now Miss Green, your full name is Latasha D. Green. Miss Green, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Miss Green, you may put your hand down. Now, Ms. Green, I have a document before me that is titled Judge's Explanation of Rights to Defend Us Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? Are these your initials on the line that state you like to waive your right to an attorney to represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding in Trial. You recognize this document?
Yes.
Is this your signature on the line that's titled Defendant?
Yes.
Now, Ms. Green, before you sign and initial these documents, did you read the documents? You understand what you read? Is everything in these documents true and correct to the best of your knowledge? Okay, now, Ms. Green. I read your answers. I also spoke to the prosecutor, Miss Haley Simmons. You talked to her earlier. And she indicated that this case needed to be reset so that she could have some time to talk to the victim regarding restitution. Is that correct? Okay.
Yes, Your Honor.
Okay, so your case is going to be reset. Give us a reset date. Okay, this case will be reset to November 19th, 2025. Ms. Green, you'll be able to get your reset from our court coordinator. Once you get your reset, you're free to go and you have a blessed day. Just have a seat in that first chair on the wall.
Yeah, that's it.
Kaylin Lane Williams. Ms. Williams, did I pronounce your name? Okay. Ms. Williams, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Williams, you may put your hand down. How are you doing, Ms. Williams? I'm doing fine. Thanks for asking. Ms. Williams, I have before me a document that's titled Business Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that state you like to apply for court-appointed attorney? I also have another document that is titled Affidavit of Indigence. You recognize this document? You have to speak up.
Oh, yeah.
And on page 2 of the same document, there's a signature on the line that's titled Defendant Signature. Is this your signature?
Yeah.
Now, Ms. Williams, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read?
Yeah.
And is everything in these documents true and correct
Yeah.
to the best of your knowledge?
True.
Okay, Ms. Williams, I read your answers. Based on your answers, meet the eligibility requirements for you meet the eligibility requirements for the appointment of a court-appointed attorney. I have to go over his bond condition. You meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Nicholas Jeter. Attorney Jeter will be given information to contact you. What's that? And you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go and you have a blessed day. Mr. You're gonna have a seat in that chair on the wall. Mr. Balzar, would you please come back up? I need to give you some bond conditions.
19. This name called me on guard.
Now, Mr. Barzar, the document that you have before you is titled Standard Bond Conditions in County Court at Law number 2. Okay? And it states, following the return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? Now, condition number 3 does not apply. However, condition number 4 does apply because your offense, which is a DWI second, is listed as a subsequent offense under section 49.04 through 49.06 of the Texas Penal Code. And condition number 4 states, a defendant whose information charges any subsequent offense listed under section 49.04 through 49.06 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator. And said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before 3 days after the date. So you have to get an ignition interlock device on any vehicle that you own or operate. Okay? If you do not own a vehicle or if you do not drive, you don't have to get one. Okay? Do you understand that?
Yes.
Okay. Now, the other thing is a defendant shall obtain, maintain, pay for, and have no violations with the ignition interlock device, mobile device. Any violation will be grounds for revocation. You're talking about ground for revocation of your bond, which means your bond can be revoked and you can be placed in a county jail. Do you understand that? Now, condition number 6, defendant must attend AA, NA meetings 3 times a week and provide proof to the court. Okay? And I see you live in Houston, right?
There you go.
So you would have to go to, I guess, one of the locations, or if, I don't know if they do it by Zoom or how. You have to contact one of the AA facilities in Houston and you'd have to attend there, okay? Now, I have a sign-in sheet that I can give to you. So when you go to the AA, NA meetings, I give you 2 of them. The sponsor will sign it. And then when you come to court, you need to bring that sign-in sheet back to court so that we can verify that you have been attending the AA any meetings. Now I need to sign that order. Let me give it, that order that he has. Thank you. And if you get the interlock, you can give proof to your attorney, and your attorney could either fax it, email it, or bring it to the court. All right, you're free to go. You have a blessed day. Hold on a minute. That's the gentleman who sat in the trial with, Jeter. Hold on. Ms. Jackson, your full name is Kara Jackson? Ms. Jackson, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Jackson, you may put your hand down. How are you doing, Ms. Jackson? I'm doing fine, thanks for asking. Ms. Jackson, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit. You recognize this document?
Yes.
On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes.
Now, Ms. Jackson, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes.
Ms. Jackson, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you is Attorney John Macy. Attorney Macy will be given information to contact you, and you will be given information to contact him. Court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day.
You too, sir. Thank you.
You're welcome. Carbon Ford. Mr. Ford, your full name is Carbon Ford.
Yes, Your Honor.
Mr. Ford, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Ford, you may put your hand down. How are you doing?
Okay.
I'm doing fine, thanks for asking. Mr. Ford, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Affidavit of Indigence. Do you recognize this document?
Yes.
On page 2 of this same document, there's a set of initials, excuse me, there's a signature on the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Mr. Ford, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Ford, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Ryan Matuska. Attorney Matuska will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day.
You too.
Now, Mr. Ford, before you do that, I see that you did not come here alone. Who do you have here with you?
Mother and my aunt.
Your mother and your aunt. Thanks for coming down here with Mr. Ford. Now, Mr. Ford, you seem to be a pretty young man. I used to be young in my day. How old are you?
I'm 18 years old.
You know what? I was 18 years old for 365 days. Okay? But that was many moons ago. But I know people like your age, you always say, they say, we have friends, you say these days, you say that's your BFF, best friend for life. Some people say that's my ride or die, meaning that, they'll be with me through thick and thin. But, on days like today, I see your mom and your aunt here. There's people that you call your BFF or your ride or die. They're not here because they had other things better to do in their life. But you know what? Those two people there was nothing else in this world better than to be down here with you. And you know why? Because they love you. And let me tell you this here. Everybody's not your friend. Everybody's not your partner. But when those two people say they got you, they got you. Okay?
Yes.
Now, I know that this is not the proudest day in their life. You might think that, you're going through a storm. But just remember this, when you're walking through a storm, hold your head high. Don't be afraid of the dark. At the end of the storm, there's a golden sky and a sweet silver song of a lark. Walk on through the wind, walk on through the rain, those your dreams be tossed and blown. Walk on with hope in your heart. And you'll never walk alone. Just remember that. There's one thing about hope. Hope floats. So when you're drowning in the sea of confusion, just hold on to that hope, because that'll keep your head above water. Okay?
Yes, sir.
So you'll be all right. You have been appointed Mr. Matuska. Make sure you contact Mr. Matuska. He is a able attorney, and he'll do everything in his power to make sure that justice is done in your case. Okay?
Yes, sir.
Now, you're going to have a seat in that third chair. Wait for your name to be called. Once your name is called, you'll be free to go, and you have a blessed day.
Yes.
And folks, thanks for coming out here with it. Okay, you're welcome. Here you go. Hey, is that Johnny Jones or John A. Jones?
Janae.
Oh, okay. Janae. Okay. Ms. Jones, your full name is Janae Jones?
Yes.
Ms. Jones, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, help you God? Ms. Jones, you may put your hand down. How are you doing, Ms. Jones? That's good. Now, Ms. Jones, I have before me a document that is
Jackson.
titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Sir? No, let me see.
Yes,
Yes,
Judge's
sir.
explanation.
Yes,
And is this your signature on the line that's titled defendant?
yes, sir.
Or are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have a document that is titled Affidavit of Indigence. Do you recognize this document?
Yes, sir.
Okay. On page 2 of this same document, There's a signature above the line that's titled defendant signature. Is this your signature? Now, Ms. Jones, before you sign and initial all of these documents, did you read the documents?
Yes,
Did you understand what you read?
yes,
Is everything in these documents true and correct to the best of your knowledge?
yes, sir.
Ms. Jones, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Lori Perazzo. Ms. Perazzo will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that chair on the wall.
Okay.
Yes.
Actually, Your Honor, I stayed 2 hours away from you. And I don't have the transportation.
Okay, no problem, because your attorney, Ms. Barrazo, is well aware that you can appear via Zoom. Okay, now the court coordinator, just remind her to give you that Zoom number.
I understand the charge.
Your attorney will, it says the charge is enticing a child away from custody. That's the charge.
Oh, it's working.
Okay? Okay, so, but your attorney will get, your attorney will get the evidence from the state, and they'll be able to, she'll be able to explain everything to you. Okay? All right. She can get a purse now, or what? Or she get it when that's your purse?
Yeah.
Yeah, okay, get your purse, and you could have a seat in that second chair on the wall.
Okay, thank you.
You're welcome.
They,
No, I heard something I
I know.
said.
this young lady, young lady.
Hold on a minute, the man. Okay, this is cause number 25 CCCR 1988. Case is styled the state of Texas versus Alexander Renee DeMontre Gonzalez. That's what it looks like,
This is Gonzalez.
Okay. Okay, that'll be up to the state to do something, but that's what it had. It has
Yeah, I don't know.
Alexander Renee DeMontre Gonzalez. Could be a typo. But Mr. Gonzalez, how are you doing?
I'm doing good, how you doing?
All right. Now, Mr. Gonzalez, would you please raise your right hand? Mr. Gonzalez, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Sorry.
Mr. Gonzalez, you may put your hand down. Again, Mr. Gonzalez, how are you doing?
Doing good.
You doing good? I'm doing fine, thanks for asking. Now, Mr. Gonzalez, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Or are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I have another document that is titled Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
Now, Mr. Gonzalez, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay. Let's see, Mr. Gonzalez. Mr. Gonzalez, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Nathan Reynolds. Attorney Reynolds will be given information to contact you,
So,
and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go.
Mhm.
You have a blessed day. Please have a seat in that chair on the wall.
yes, sir. I was letting you know too. I also stay 5 hours away from here. I stay in Dallas.
Okay,
So,
make sure you get the Zoom number, and your attorney should be contacting you within the next, is it 24 hours?
24.
Yeah, and then you can get all that information to your attorney. You have the Zoom number. If you need to appear via Zoom on your next court appearance, you'll be able to appear via Zoom because that's just an announcement.
okay, thank you.
Okay, all right, just have a seat in that chair on the wall. Oh. Court is in session in two cases. Cause numbers 25 CCCR 2012 and cause number 25 CCCR 2013. Both cases are style of state of Texas versus Brandon Ross Davenport. Mr. Davenport. hmm? Your middle name is different?
Royce, that's just like, no, it's Royce. Royce.
Royce. Okay, they have Ross in here. This is Roy. Oh, so it's Royce, like Rolls Royce. Okay. How are you doing, Mr. Davenport?
I'm doing the horse.
That's good. Now, Mr. Davenport, who do you have here with you? Grandmother, thanks for coming down here with your grandson. Now, Mr. Davenport, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
Or are these your initials on the line that state you like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that's titled defendant's signature. Is this your signature?
Yes, sir.
Now, Mr. Davenport, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
Mr. Davenport, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Marva Provo. Attorney Provo will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Now, before she gives you that information, a bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law number 2. Do you see that document? And I'm going to go over this document with you, and it states, following the return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional condition. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or against the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test of drugs and alcohol when directed to do so by the court, or B, submit to a test of drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Now, condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states that the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
And condition number 7, the defendant shall wear a global positioning monitoring system device at the defendant's expense with written verification being submitted to the court within 3 days. That's a GPS device. Okay. Now you're required to, now do you understand that condition? Oh, he has to wear this. I think some people kind of refer to it as a electronic monitor or ankle monitor. He's required to have that as a condition of his bond.
Right.
Okay, okay,
But for as long as we,
the case is pending. And then once the case is, or as long as he's on bond. Right, now, normally the bond lasts until the case is disposed of. Once the case is disposed of, you're no longer under the bond conditions. Okay,
when will he be getting his device?
she can, she'll give you the information. Okay, now, do you understand these conditions?
Yes, sir.
Now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested, placed in the Jefferson County Jail. Do you understand that?
Yes, sir.
Okay, please, have a seat in that chair. Wait for your name to be called. Once your name is called, you can go to the window. And y'all have a blessed day now. You can come back on up. Now, I know you heard the speech that I gave to that other young man. Okay. How old are you? You're 19. That other gentleman was 18, so you're 19. Now, and you have your grandmother here with you, okay? And as I mentioned to the other gentleman, you know, a lot of times people put a lot of stock or value in their friends, okay? You know, you call them your BFF, your ride or die. They'll be with you through thick and thin, but on days like the day when you need a friend, the people that you call your ride or die is not here, right? And I always tell young people, everybody's not your friend, everybody's not your partner. But your grandmother's here. I bet when that lady says she got you, she got you. Okay. You know, ma'am, thanks for coming down here with your grandson. He, you know, he has these charges filed against him. He has an able attorney that has been appointed to represent him, who's going to look after his legal right, going to protect his legal rights. Now, I think that what you should bear in mind is that you're in the criminal justice system now, okay? And so we're in the criminal justice system. This is, you know, that's not a game. It's serious business. And because of that, you know, you have legal rights. You have an attorney that's going to make sure that your rights are protected. You have to bear in mind that even though you're in this storm, you remember that when you're walking through a storm, hold your head high. Don't be afraid of the dark. At the end of the storm, there's a golden sky and a sweet silver song of the law. Walk on through the wind, walk on through the rain, though your dreams be tossed and blown. Walk on with hope in your heart, and you never walk alone. And as I mentioned to the other young man earlier, there's one thing about hope, hope floats. So when you're in a sea of confusion, drowning, just remember to hold on to that hope, okay? That's one thing that you can hold on to, all right? This process is, well, it's a journey, but you have your grandmom here as well as your attorney to go on this journey with you, okay? And they're gonna do their best to make sure that everything is done right. All right. Now, before the night is over, you need to get that lady right there a big hug and a kiss for being down here with you, because I know she had other things to do, but it was not more important than to be here with you. Okay. Everybody don't have somebody like you have. But you have a grandmother that loves you, right? That's a blessing. Okay. And you ought to thank God for that. And so, as I mentioned to you earlier, just be patient with this process, and eventually you'll be through this process. All right.
Yes, sir.
Okay. If you you know, feeling down or anything, make sure you reach out to your attorney. Make sure you let her know so that you can get the help that you may need. Okay. Just remember, I just don't want you to think that you're alone, because you know a lot of times when people think they're alone, they panic and they do things that they shouldn't do. But you're not alone. Okay. You have an attorney your grandmother, you have probably you have some support system around you. So just be patient. You know, a lot of times at least this is what I see. Some young people are just somewhat impatient, you know. But as I mentioned to that other young man, I was in your age, I was your age 365 days, but that was a long time ago. I'm looking through my rearview mirror. Okay. Your grandma, where you going, she's already been, the instructions that she has given to you in the past, and even now, it was because she was trying to get you to avoid some of the pitfalls that lie ahead. Okay. She wants you to avoid some of those pitfalls, right? And so it's always a good thing to, listen to your elders. All right. But you'll be all right. And just like I tell people, he'll be all right. Don't give up on him. I tell people this all the time. Don't hang up. Hang on. Just hang on to him. He'll be all right. All right. And thanks for coming out here with your grandson. You're welcome.
Yes, 2,000.
Yeah. Yeah, I didn't. Yeah, put that. Yeah, I didn't put that number. I have it on here. Joshua Simon. Say the best for last. All right. Now, Mr. Simon, your full name, let's see, is Joshua Dwayne Simon. Mr. Simon, would you please raise your right hand? Simon, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God? Mr. Simon, you may put your hand down. How are you doing, Mr. Simon?
Good.
Well, that's good. Now, Mr. Simon, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant? At the top of this document, there's a set of initials stating that you would like to have your case reset to hire your own attorney.
Yes.
Now, before you sign any initial this document, did you read the document?
Yeah.
Did you understand what you read? And is everything in this document true and correct to the best of your knowledge?
Yes,
Mr. Simon, I read your answers. Based on your answers, your case will be reset to give you an opportunity to hire your own attorney. But before I let you go, I need to give you some bond conditions. You can step to your left. Okay, and then you can step back in front of the podium or in front of the bench. Now, Mr. Simon, this document is standard bond conditions in County Code at Law Number 2, and it states, following return of criminal information in County Code at Law Number 2, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? You understand that? Okay, just one at a time. Okay, we starting off with number 1. I see you went all the way to number 7. Okay, you gotta stay focused. All right.
Yes.
And number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test of drugs and alcohol when directed to do so by the court, or B, submit to a test of drugs and alcohol and a test in the case of presence of drugs and alcohol in the defendant's body. Do you understand that condition?
That's right.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Stay next door, our yards combined there.
Well, you just can't go,
Box next.
well, you next door, you can't go to his residence.
Huh?
You can't go near his residence.
Nah, I don't go.
I mean, you stay on your property, stay on his.
Yeah,
Okay,
that's the reason we in this now.
okay, well, it's more than that, according to the proper cause affidavit. Okay. Now, do you understand that condition?
Yes, sir.
Okay. Now, number 4 does not apply because that only applies in a DWI case. Your case is not a DWI case. Number 5 does apply And number 5 states, defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer, as defined by section 1.07 Penal Code Act, and may engage in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
And condition number 7. Defendant shall wear a global positioning monitoring system device at the defendant's expense with written verification being submitted to the court within 3 days. Do you understand that?
Yes, sir.
Okay, now if you violate these conditions, your bond can't be revoked, and if your bond is revoked, warrant will be issued for your arrest, you'll be arrested and placed in the Jefferson County Jail. Do you understand?
Yes, sir.
All right, just have a seat in that second chair and wait for your name to be called. Jefferson County Court at Law number 2 is back in session. The court is in session. Oh. Okay, this is cause number 25 CCCR 1522. Case is filed in the state of Texas versus Marissa Terrell Hearn. Marissa Hearn was scheduled to be in court this morning at 9 a.m. At about 9 a.m., court's bailiff called the name of Marissa Hearn at the courthouse door. Marissa Hearn did not answer. Marissa Hearn has not appeared in court since the court has been in session. The time now is 12:28 p.m. on today's date of October 7, 2025. Ms. Bailiff, would you please call the name of Marissa Hearn at the courthouse door?
Marissa Hearn. Marissa Hearn. No response, Your Honor.
Marissa Hearn's name was just called again at the courthouse door. Marissa Hearn did not answer. A reasonable time has passed to give Ms. Hearn an opportunity to appear in court. She has not appeared in court. State, do you have a motion? That motion will be granted. Marissa Hearn's bond will be forfeited and a warrant will be issued for her arrest in cause number 25 CCCR 1522. Next case is cause numbers 25 CCCR 0632 and cause number 25 CCCR 0633. Both cases are styled in the state of Texas versus Zaire Shelby. Zaire Shelby was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Zaire Shelby at the courthouse door. Zaire Shelby did not answer. Zaire Shelby has not appeared in the court since the court has been in session. The time now is 12:29 p.m. on today's date of October 7, 2025. Ms. Bailiff, could you please call the name of Zaire Shelby at the courthouse door?
Yes, sir. Zaire Shelby. Zaire Shelby. No response, Your Honor.
Zaire Shelby's name was just called again at the courthouse door. Zaire Shelby did not answer. A reasonable time has passed to give Zaire Shelby an opportunity to appear in court. Zaire Shelby has not appeared in court. State, do you have a motion?
That goes for
That-
charges, Your Honor.
Those motions will be granted. Zaire Shelby's bonds will be forfeited and a warrant should be issued for her arrest in cause numbers 25 CCCR 0632 and cause number 25 CCCR 0633. And this will conclude the calling of the court's arraignment docket in County Court at Law number 2, Jefferson County, Texas, on today's date, October 7, 2025. Judge Terrence Holmes presiding. Attorney Hilton, you're free to go and you have a blessed day.
Thank you, Your Honor. Well, that's
Okay, the court is back in session with arraignment docket. There's one case that we still have, which is cause number 25 CCCR 1506, case of style of state of Texas versus Vicky Bullion Wally. Vicky Wally was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's be able to call the name of Vicky Wally at the courthouse door. Vicky Wally did not answer. Vicky Wally has not appeared in court since the court has been in session. The time now is 12:33 p.m. on today's date of October 7th, 2025. Ms. Bailiff, would you please call the name of Vicky Wally at the courthouse door?
Vicky Wiley, Vicky Wiley. No response, Your Honor.
Okay, Vicky Wiley's name was just called again at the courthouse door. Vicky Wiley did not answer. Vicky Wiley has not appeared in court since the court has been in session. Vicky Wiley has been given a reasonable time to appear in court. She has not appeared in court. State, do you have a motion? That motion will be granted. Vicky Wiley's bond will be forfeited. Warrant should be issued for her arrest in cause number 25 CCCR 1506. And this will conclude the calling of the court's arraignment docket on today's date, October 7th, 2025, in county court at law number 2, Jefferson County, Texas. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day. And Attorney Hilton, you're free to go. You have a blessed day. Everyone, please have a blessed day.
On that new vision, it's out of